Hi, I'm Elizabeth Talbot with the Talbot Law Group in Walnut Creek, California, and we are a trust and probate law firm who handles a lot of estates that are going through the probate process in California. So I wanted to talk today about how the attorney for the administrator of the estate's fees work. Now, often the administrator is called an executor, but the general overarching term is administrator. So often that administrator will have an attorney, and he or she takes fees as outlined by California law, not simply that attorney's hourly rate, as would be the case in a normal probate or trust matter. So how do those fees work? There's two kinds. First, there are statutory fees, and second, there are extraordinary fees. Now, these types of fees can also be taken by the administrator or executor himself or herself. But let's just talk about the attorney's statutory fees first. So the statutory fees are outlined by California law, and they are as follows. It's 4% of the first $100,000, 3% of the next $100,000, and 2% up to $1 million. And then after $1 million, it starts to decrease. So 1% on the next $9 million, and then 1/2% on the next amount above that, which is pretty rare to see above $10 million of probate. Okay, so those are the statutory fees, and those are also taken, those exact same percentages are taken by the administrator. So the administrator and the attorney will have the exact same statutory fees. Now, what do those statutory fees cover for an attorney? Well, they cover all of the standard estate work. What is standard estate work? I actually have another video where I go over all the different things that an attorney should be doing for you that is considered standard estate work. But basically, it's setting up the estate, doing all the work that is included in the administration of the estate, and then closing the estate. It does not include things like sale of real property and litigation. Those are probably two things that come up the most often in our probate matters that are not covered by statutory fees. So how are those types of things paid for in a probate? They are considered extraordinary work. So that's a second type of fee in a probate matter. There's the statutory fee and statutory work, and there's the extraordinary fees and extraordinary work. And extraordinary is really meant to cover anything that's above and beyond the normal course of a probate that doesn't normally occur in every probate. So a real common one is sale of real property. Now, sometimes if we have a non-litigated probate, everything is very standard, there's nothing crazy happening, we won't actually take any extraordinary fees to deal with the sale of real property because it may be very uncomplicated. Okay, so that's the first thing. The second thing is litigation. Litigation is always billed as extraordinary work, and extraordinary work is just at an hourly rate, whatever the attorney's hourly rate is that is accepted by the county. So litigation, very significant complications, like we have all kinds of matters that have trust aspects or litigated parts over a prenup with someone who was married in China. I mean, you name it, we have seen it. So those types of things in the course of a probate would be considered extraordinary fees. So the important thing to know about these two types of fees is that in the end, they are not paid up front. They're paid when the judge actually signs an order granting all the attorney's fees. So at the end of the probate process, the attorney has to petition the court for the fees, tell them what work they've done, and it's up to the court whether or not to grant those fees. Generally, statutory fees are always granted, that's a given, and then the judge has the discretion to either grant, reduce, or completely eliminate extraordinary fees. So that's a general overview of how attorney fees and administrator fees also work within a probate in California. Thanks so much.